Hello, and welcome to the last lecture in the advocacy course. I'm your instructor, Anita John, and we're going to be covering the last chapter, chapter 18, the ethics of advocacy. So problem 1, your client is being cross-examined by opposing counsel, and then there's a break for lunch. And at lunch, you discuss with your client anticipated areas yet to be covered on the cross-examination. The question is this ethical? Is this unethical? And the answer is yes. So I refer you to read page 421 in our core text, an advocacy primer. And in the textbook, it lists various situations where it's prohibited for counsel and advocates to talk to their clients at various stages of the trial. So the one that I just flagged out is that during cross-examination by an opposing lawyer, the witness's own lawyer or own advocate or own paralegal ought not to have any conversation with the witness about the witness's evidence or any issue in the proceeding. So that's sort of ethical issue number 1. Problem number 2 deals with guilty pleas. So let's say your client is charged with mischief and he says he's innocent, but he wants to plead guilty and he wants to go over the matter with you. And he concludes that he doesn't want to lose a day work and it's just inconvenient and he doesn't want to pay costs. As an advocate, should you assist him in entering a guilty plea? The answer, unless the client is prepared to admit to the mental and factual elements, your duty and your ethical obligation is not to assist in entering the guilty plea, because that would be perjury and that'd be lying in court. So as an advocate, you have an ethical obligation to make sure that your client must admit the factual and mental elements of a guilty plea. Now for problem number 3, withdrawing as counsel. Again, your client is charged with a break and enter of a neighbor's house and he steals a laptop, and then he gets arrested by the police for trying to pawn the laptop. And then in an interview with you in confidence, he admits that he did steal the laptop. However, when the trial date comes and he takes a stand, he insists on lying on the stand and saying that a disabled person gave him the computer. You are certain as an advocate he's lying. So the ethical issue is, do you withdraw? And the answer to that is you know that your client is going to commit perjury. And so the rules of professional conduct state for paralegals that you cannot knowingly attempt to deceive or to participate in a deception of a trial by offering false evidence. So in this case, you are obliged to withdraw, and the difficulty is, how do you withdraw? And so as an officer of the court, you don't spill the beans about your client's information. You just say that you have to withdraw and for good cause, and you leave it at that. So it's for good cause. And so the rules of professional conduct, specifically Rule 3.08 subsection 2, says a paralegal may withdraw if there's been a serious loss of confidence between the paralegal and the client. And what does a serious loss of confidence means? It means when a client lies to you or is asking you to do something that would mislead the tribunal. And so if you withdraw on the basis of Rule 3.08 subsection 2, and without disclosing it on the record, that would be a permissible withdrawal. Problem number 4, client confidentiality. So your client is a hit and run driver, and he comes to you for advice about further information on his behalf without revealing his identity. The injured party, the other side, seeks to have your client's identity revealed. So the ethical obligation or the ethical issue is, do you have an obligation to disclose your client's identity to the injured party? And the answer to that question is no. It is possible that confidentiality, that broad blanket of confidentiality, also includes the identity of your client. So the rule is very broad, the rules of professional conduct. Rule 3.03 states that a paralegal shall at all times hold in strict confidence all information concerning the business and affairs of a client acquired in the course of the professional relationship, and shall not disclose that information unless the client expressly consents, or if there's some kind of implication, or it's required by law. So it is conceivable and it is possible that you don't have to disclose your client's identity, because that's all part and parcel of client confidentiality. Problem number 5, disclosure of law. So let's say you're dealing with a problem and the Supreme Court of Canada has recently released a decision that's on point. However, the decision is not in your favor. It's not in your corner. And you're at closing argument, and your opponent, the opposing advocate, has just completed closing argument, but they fail to mention the case. So the ethical issue is, do you bring the case to the attention of the court? And the answer to this issue is yes. Your obligation to the court prevails over your loyalty to the client. And I turn your attention to Rule 4.01, subsection 5D of the Rules of Professional Conduct. It says that an advocate must not deliberately refrain from informing the tribunal of any pertinent adverse authority that is directly on point and not been mentioned by opponent. So you have a higher calling and a duty to the court to let them know what the leading case law in an area is, even though it might be prejudicial to your client. And so I would say in our jurisdiction, you would have an obligation to definitely do Supreme Court of Canada and even Ontario Court of Appeal if that was the only decision that was available. Number 6, you act for a client in a personal injury action, and in answer to the local ad of a newspaper calling for witnesses in the accident, a gentleman by the name of Mr. Pip responds, and he comes to your office and he tells you, he testifies, or he tells you how he saw the accident, and it's very damaging to your client. You don't want to call him as a witness. Do you have to disclose his identity or the fact that he exists to the opposing side? The answer is no. As an advocate, you're under no obligation to produce a witness that will harm your client. However, on the other hand, too, you can't discourage him or dissuade this witness from coming forward to giving evidence should he wish to do so. So with issue number 7, cross-examination limits, we're going to illustrate this issue by way of hypothetical. So the facts are as follows. An advocate is cross-examining an eyewitness for a car accident, and at the time of the accident, the witness was driving his own car. The witness is a bank employee married with 3 children. He testified that he was driving to work, and the area where the accident occurred is at the city's red light district, which is frequented by prostitutes. So here's a sample of the cross-examination. You weren't watching the road, were you?
No, I was watching the road.
I'm going to suggest to you that you were trying to pick up a prostitute.
No.
Isn't that something you do quite regularly before work, right after you have your double latte at Starbucks?
I do not.
I have no further questions for this witness. Issue number 8, communicating with a represented party. So let's say you have difficulty in dealing with an adverse opposing advocate. He or she has been very unreasonable, and you're confident that if you talk to his or her client directly, the matter could be quickly resolved. Should you? And the answer to that question is no. And I direct you to Rule 4.02, subsection 2 of the Rules of Professional Conduct for Paralegals. And an advocate should not approach or deal with an opposite party who is professionally represented unless that other counsel or the other lawyer or the other advocate gives their consent. So the rules are very strict on this, so you don't approach another lawyer or another advocate's witness. If you want to talk to them about a matter, you have to still keep trying to talk to counsel or the advocate or the paralegal. So that concludes our discussion of ethical issues that you may face as an advocate in court. All I can say is remember the golden rule: do unto others as you would like them to do unto you. Treat the court, opposing advocates, and witnesses with respect and fairly. And I think William Shakespeare said it best in Hamlet, in Act 1, Scene 2, when he wrote, "This above all, to thine own self be true, and it must follow as the night the day, that thou cannot be then false to any man. Thank you.